How do courts decide whether someone was careless enough to be liable in negligence? It all comes down to breach of duty, and the answer is more nuanced than simply asking whether something went wrong. Once a claimant establishes that a duty of care is owed to them, they must clear the second hurdle, proving that the defendant breached that duty. Breach is assessed by setting a standard of care and asking whether the defendant fell below it. We have 5 building blocks to cover. The foundation of breach is the objective reasonable person test, famously articulated in Blythe v. Birmingham Waterworks in 1856. The court asks, what would a reasonable person have done in the defendant's position? This is not a subjective test. The defendant's personal skills, nervousness, or inexperience are irrelevant. A learner driver is judged against the standard of a competent driver, not against what you would expect from someone on their first lesson. That was confirmed in Nettleship v. Weston in 1971. The standard is constant, external, and impersonal. When a defendant holds themselves out as having a special skill, the standard rises accordingly. They are judged against a reasonable, competent professional in that field, not against the man on the Clapham omnibus. The leading case is Bolam v. Free and Hospital Management Committee from 1957, where McNair J. held that a doctor is not negligent if acting in accordance with a practice accepted as proper by a responsible body of medical opinion. But there is an important qualification added by the House of Lords in Bolifo v. City and Hackney HA in 1998. That body of opinion must withstand logical analysis. Courts will not simply rubber stamp any expert consensus. If the opinion cannot be logically defended, it will not provide a defense. This keeps professional defendants genuinely accountable. Even with the standard set, courts do not find breach automatically. They weigh several factors that increase or decrease the likelihood that a reasonable person would have taken precautions. First, the probability of harm. If an injury is very unlikely, less precaution is expected. Bolton v. Stone, 1951, where a cricket ball clearing a high fence was a very rare event. Second, the severity of potential harm. If the consequences could be catastrophic, the standard rises. In Paris, Fives Stepney Borough Council, 1951, the council employed a one-eyed man on work carrying a risk of eye injury. The severity for him was total blindness, so greater precaution was required. Third, where the defendant has special knowledge of the claimant's vulnerability, that raises the expected standard further. Risk alone does not determine breach. Courts also look at what it would have cost, or how burdensome it would have been to take precautions. In Latimer v. AEC Leltied in 1953, a factory floor flooded and became slippery. The employers spread sawdust, but some areas remained dangerous. The Court of Appeal held there was no breach. Closing the whole factory would have been disproportionate given the modest residual risk. The social utility of the defendant's conduct also matters. In Watt v. Hertfordshire County Council, 1954, a fire engine rushed to an emergency without the proper equipment to carry a heavy jack. A firefighter was injured. No breach. The social value of saving a life outweighed the risk, so the court balances the risk factors on one side of the scales against the burden and utility factors on the other. Putting it together, breach is found when the risk factors outweigh what it would have cost to take precautions, when a reasonable person in the defendant's position would have acted differently. If the defendant took reasonable precautions and the harm still occurred, that is not enough for breach. It is ultimately a question of fact for the judge, in each case, not a pure rule of law. The claimant bears the burden of proving on the balance of probabilities that the defendant fell below the required standard. Time for a check. A surgeon performs an operation using a technique accepted by a responsible body of medical opinion, but a different group of expert surgeons disagrees with it. Is the surgeon in breach of duty? Option A, yes. Any expert disagreement means breach. Option B, no. Following a responsible body of opinion satisfies the Bolam test. Option C, yes. The majority expert view always governs. Option D, no. Surgeons are never liable for clinical judgment. The answer is B. Under Bolam, provided the surgeon's approach is accepted as proper by a responsible body of opinion in that field, there is no breach. The mere existence of a contrary view does not make the conduct negligent, as long as the accepted view is also logically defensible under Bolifo. Breach of duty asks whether the defendant fell below the standard of the reasonable person or the reasonable competent professional, after weighing the probability and severity of harm, the vulnerability of the claimant, the cost of precautions, and the social utility of the defendant's conduct. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations, try it free for 7 days, link in the description.